Welcome, everybody. And we are here tonight reporting on one of the biggest legal stories right now today, and something that is going to be a hotbed for controversy as this case makes it through. You're seeing it right over here. The United States invaded a country last night and arrested its president, and that is exactly what happened. And we're going to talk about it because we have this article is up on our website, but we're going to talk about something that every American needs to make themselves aware of, and that is the Ker-Frisbie Doctrine. This is a 140-year-old legal principle that's going to decide Maduro's fate as far as whether or not he has to stand trial. And we're going to get into all of it because this is absolutely unbelievable. And this has the potential to shape how other cases, other things are handled, and we're going to explain why, what's going on here, why the government believed this was an okay action, and we're going to get into all the law. And there's going to be a big battle that is going to ultimately go to the United States Supreme Court, and there will be a moment where the United States Supreme Court is going to have to decide to support its president or to support the president of an enemy nation, or at least a nation that's been declared an enemy. We're going to walk through everything that's happened, how we got here, and what this is looking like. So stay tuned, guys. Let's jump into it. Let's first start by reviewing and getting into exactly what happened and how this went down. At approximately 1:50 a.m. earlier today, January 3rd, explosions lit up the night in Caracas, Venezuela. And within hours, our president, Donald Trump, announced that U.S. forces had captured Venezuelan President Nicolás Maduro and his wife, Celia Flores, and extracted them from their home, and that they were transporting them on the USS Iwo Jima. This is a exclusive photo of Maduro on the USS Iwo Jima. And Trump released this photo of him blindfolded, restrained, wearing a gray sweatsuit aboard a U.S. warship. And you're going to see why some of this is, and it's very important that the way he is brought back is done without any problems. I can't get into all the words that they would use to describe things, but you're going to see that it's important that he's brought directly back to New York, and that he's done so humanely, fairly, and with an eye for due process, if you could call this due process. It's certainly not going into a country the way they did, ignoring international laws and doing something that every country in the world right now has decried. And we're going to talk about the impact of that. But that is Mr. Maduro right now, or as we speak, as he's being transported. I'm sure we'll be notified as soon as he reaches New York City. Now, this is not a movie. Seems like it is. This is not a drill. It seems like it would be. This is reality. And this is what happened when the military has just conducted an invasion of a sovereign nation and arrested its sitting head of state to bring him to trial in federal U.S. court in Manhattan. It's like something out of a movie. It's like something out of a TV show. And it's unbelievable, but it's happened. And look, I am not a Nicolás Maduro supporter. Okay, there's plenty to criticize about the man. I make that very clear in this article. But what we're here for is it's about law, constitutional authority, and the foundational principles that separate a nation of laws from a nation of men and madmen. And we have to sit on the side of the law. There's a way to do it and a way not to do it. That's what separates us from them. And the danger, as you're going to see, of operating like we don't have laws means we are now operating in a playing field that is completely different than anything we've ever operated in. And it's a scary thought. But we're going to get into all of this. So what happened? Like I said, shortly before 2 a.m., multiple explosions rocked the city. It was a full-out military exercise. There was footage verifying this from various news organizations. They struck 2 airports, a port facility, and areas near Fort Tuona, Venezuela, or Fort Tuona, which is Venezuela's largest military installation. The operation was carried out by the U.S. Army's elite Delta Force, working alongside FBI agents to have been positioned to make the arrest. And this is important because they had to embed the FBI in order to make this work and in order to make this fall under the portion of law that they believe made this a legal event. According to Trump's own account, CIA operatives have been on the ground since August, and you're going to see that this was set up very carefully. And you're going to start to see that everything that was being done, if you were following this situation, was being done to ensure that when they went in to arrest Maduro, that this would fall potentially under the lawful principles of what they believe is case law that supports their operation. Now, that remains to be seen. It looks like they've got a pretty strong chance that they're not going to have a problem prosecuting Maduro, but there is something that Maduro's attorneys will be arguing, and that's going to come up, and we're going to talk about that in a little while. So stick around, don't leave, because you want to hear this. Trump described the location as a house that was more like a fortress than a house. He said it had steel doors. Now, he watched the whole operation from Mar-a-Lago. So Maduro and his wife, they were extracted from their bedroom, transported to the USS Iwo Jima, which is an amphibious assault ship that had been brought down to the Caribbean earlier in 2025, and they are now en route. And that is a picture of the USS Iwo Jima. Now, Venezuela Vice President Delcy Rodriguez, who was installed shortly after this whole event went down, appeared on TV earlier today demanding proof of life for Maduro and his wife and stating that the Venezuelan officials did not know their whereabouts following this U.S. attack, which she called an assault on Venezuelan sovereignty that had savagely attacked the nation's territorial integrity. Trump announced that the United States would run Venezuela temporarily, which is insane. I mean, that's another insane aspect here. We're going to go take someone's president, and then we're going to just install our own forces to run the country. Whether you agree with Venezuela or anything or not, there's a way to do this and a way to not, and that's what we're following, and that's what we're covering. That's what the issue is here. It's not about whether or not there should be another leader. It's about doing it the right way and setting that example as a nation who's saying we can't have people ruling countries and doing things that are not following international law, not following stuff, but by us violating international law to get there, it's a big problem. Now, the president was quoted as saying, the United States of America has successfully carried out a large-scale strike against Venezuela and its leader. President Nicolás Maduro has been, along with his wife, captured and flown out of the country. This operation was done in conjunction with U.S. law enforcement. Now, the timeline for this, and we have it broken down here, this all begins, believe it or not, back in March of 2020. It was in March of 2020 that the U.S. Department of Justice indicted Maduro on what they're called narco-terrorism charges, alleging that he led an organization called the Cartel de los Soles and partnered with FARC to traffic cocaine into the United States. At that time, there was a $15 million bounty for information leading to his arrest put on. Now, fast forward to August of 2025. Trump is reelected. Fast forward to January of 2025. Sorry, I skipped ahead in the timeline here. Final days of the Biden administration, a bounty for Maduro's arrest has increased to $25 million. January 20th, inauguration day, Trump signs an executive order. Now, this is where it's important to now go back, and you're going to understand when we get into this, each and every action that was taken and why it was taken. And you're going to start to see it now as you start to understand what Trump needed to do in order to make this legal. So Trump signs an executive order paving the way for criminal organizations and drug cartels to be designated as foreign organizations. You can see it on the screen. All right. I can't say it. Including Tren de Agua. I don't know if I'm saying it right, which was a Venezuelan street gang. Okay. So that's step number one. Now, in August, the bounty for Maduro's arrest is increased to $50 million. Trump designates the Cartel de los Soles as a foreign organization, placing Maduro on the same list as Al-Qaeda and the Houthi rebel group, CIA operatives then use that authorization and use that action to begin clandestine operations on the ground in Venezuela. So it's very important to understand what, now you can see why these things were happening, because now they're a foreign group, and you're going to see that the way the law reads, in order for them to get away and prosecute under this, in order for them to avoid the exception that Maduro's attorneys are going to try to compel, all of these things must be happening in this way, because Maduro must be seen as not a recognized leader. And this is all part of the discrediting of Maduro, especially since the United States has held since 2024 that Maduro is not the leader due to the heavily controversial election that came out of Maduro's election in 2024. Since then, the United States has held that Maduro is not the elected leader, and you're going to see why that matters. Now, the first U.S. military strikes on alleged drug smuggling boats in the Caribbean begin. The administration claims the boats are carrying drugs bound for the United States. Over the following months, more than 35 boats are destroyed, killing at least 115 people. The administration provides no evidence of the boats actually carrying any type of drugs. In October 2025, Trump publicly confirms that he has authorized the CIA to conduct covert operations inside Venezuela. Now, Venezuela government requested an emergency meeting at the United Nations Security Council, and they described mounting threats from the United States. Move forward into November 2025. Trump administration officially designates Maduro as head of a foreign organization. Trump announces on Truth Social that airlines, pilots, dealers, and should consider the airspace above and surrounding Venezuela to be closed in its entirety. Now, December 2nd, things really intensify. He says, Trump lets everyone know that he's intending to do strikes on land, and that he says land is much easier, and we know the routes they take. We know everything about them. We know where they live. December 10th, 2025, U.S. Coast Guard personnel with Navy backing seized the oil tanker Skipper in international waters carrying Venezuelan crude, and Trump announces a total and complete blockade of sanctioned oil tankers entering and exiting Venezuela. December 20th, 2025. Now we're only about 2 weeks out from this action. The U.S. seizes a second oil tanker off the coast of Venezuela. UN human rights experts condemn the U.S. blockade as a violation of international law, stating there is no right to enforce unilateral sanctions through an armed blockade. Now, this is the first area that the United States steps into where we have to start to say, wait a minute. You can't violate the law to attempt to try to enforce law, but that's what they're doing. And that's what he's trying to do. And that's what happens in this instance, where now for the first time, there's going to be a second time that we're going to step outside international law. We ignore international law, and that's dangerous, because what we are doing right now is setting a precedent. And a precedent, as you know, if you follow the law, is essentially you're setting a course of events based on past action. You're setting the standard based on past action. And we've lived on the standard that says we're supposed to be humane, law-abiding, and we're supposed to follow the law and follow procedure. And that has kept us out of military conflicts, and kept people at bay at times, saying, okay, yeah, we can support that. We're going to not have a military conflict here. We're going to come in and we're going to settle it as humane individuals. Well, that's going out the door, as you're going to see. Late December 2025, the CIA conducts a drone strike on a dock facility in Venezuela, on the Venezuelan coast, becoming the first known U.S. land attack on Venezuelan territory. Trump later describes it as hitting a dock area where they load boats up. And then on January 3rd, 2026, we violate international law for the second time, where we conduct a large-scale strike in Caracas, capturing Maduro and his wife, and announcing that we will now run Venezuela, which is insane. So what is going on here? Well, there are federal charges against the Maduros. Attorney Pam Bondi announced that a superseding indictment, meaning an indictment after an indictment, was unsealed in U.S. District Court, charging Maduro and his wife with multiple federal crimes. So the crimes they've been charged with. Count 1, narco-terrorism. That's a 20-year mandatory minimum up to life. Count 2, cocaine importation conspiracy. 10-year mandatory minimum up to life. Count 3, possession of machine guns and destructive devices. 30-year mandatory minimum up to life. Count 4, conspiracy to possess machine guns and destructive devices up to life. The indictment alleges that for over 25 years, the leaders of Venezuela have abused their positions of public trust and corrupted once legitimate institutions to import tons of cocaine in the United States. And the charges build on the 2020 indictment, which I mentioned was already in effect, from Trump's first term, which alleged that Maduro was the leader of the Cartel de los Soles, a network of Venezuelan military and government officials allegedly involved in drug trafficking. The new superseding indictment now adds his wife, Celia Flores, and his son as a co-defendant. Along with allegations of partnership with the Sinaloa cartel, the Zetas, and the Tren de Aragua. Remember, the Tren de Aragua were designated as international group. Okay, that's very important. These are extremely serious charges, and this means Maduro, for all practicality, will be spending the rest of his life in prison if he's convicted, and he will be going to the Supermax. And Supermax is some of the worst conditions you could ever spend your time in. So, the question, though, is, will the court have the authority to try him at all? And that is going to come, this is where we have to discuss and get into something called the Ker-Frisbie Doctrine. What is the Ker-Frisbie Doctrine? It's extremely important, and it's something that every American right now should spend some time understanding about this case, because it is going to absolutely, potentially be the way, it's either the way that Maduro gets tried or he doesn't get tried. And it's the way that our president either gets viewed as being lawful or not lawful. So it is extremely important that everyone understand this and become familiar with it. The legal principle that's going to be at the center of Maduro's defense is a term known as male captus bene detentus. Bad capture, good detention. The Ker-Frisbie Doctrine holds that it matters not how you're brought to court. It matters not whether that was lawful or illegal. It only matters that you are brought to court, informed your charges, and given a fair trial, and that satisfies due process. If you're in court, if you're standing there, and that is the way, and you're going to hear the history of this, there's a long history that we have in the United States where this has been battled and looked at. The doctrine derives from 2 Supreme Court cases that were decided 66 years apart, and it has been affirmed repeatedly in the years since. Under the principle, it doesn't matter if a defendant was kidnapped, abducted, or brought to the United States through means that violated treaties, international law, or the defendant's own rights. The trial's allowed to proceed because he's present. He's been informed of the charges, and he's going to be given his due process rights in respect to the trial of those charges. And it's the reasoning's straightforward. I just said it. Due process is satisfied when the defendant is fairly apprised of charges against him and receives a fair trial with constitutional procedural safeguards. That is the only standard that the Supreme Court of the United States says must be upheld. And the Supreme Court put it very succinctly in the case here that by the name of the doctrine. It's the Frisbie v. Collins case. And they stated in that case, there is nothing in the Constitution that requires a court to permit a guilty person rightfully convicted to escape justice because they were brought to trial against his will. And the doctrine so far has survived 140 years of challenges. But this is going to be the one, as you'll see why in a minute, that could be the one that could break the mold here and dent that armor. Now, it began in 1886 with the Kerr v. Illinois case. The doctrine began when Frederick Kerr, he was a U.S. citizen living in Peru. He was wanted on charges of larceny and embezzlement, and President Chester Arthur sent an agent to Lima, Peru, with proper papers to negotiate Kerr's extradition through official channels. However, the agent didn't want to wait. So instead of processing the extradition, he kidnaps Kerr, brings him back to the United States by force. And Kerr argued that the abduction was illegal and that the court therefore had no jurisdiction over him. Supreme Court disagrees. They said such forcible abduction is no sufficient reason why the party should not answer when brought within the jurisdiction of the court, which has the right to try him for such an offense and presents no valid objection to his trial in such court. Meaning, it didn't matter how he arrived. That's something separate that can be dealt with through, the agent who might have done something illegal or international law, whatever body wants to deal with the people that did it. But the fact that he's there, once he's dropped off there and he's in custody, he's not going out of custody. The holding was clear. It didn't matter. Then we had the Frisbie v. Collins case. That's a 1952 case. 66 years later, Shirley Collins is living in Chicago when Michigan authorities decided they wanted to try him for the Big Red Rum. Rather than go through proper interstate procedures, Michigan police cross state lines and they forcibly bring Collins from Illinois and bring him back to Michigan to stand trial. Collins is convicted. He's sentenced to life in prison. And he files a habeas corpus petition. And he argues that his kidnapping by state authorities violated the 14th Amendment's Due Process Clause and the Federal Kidnapping Act. Now, Justice Hugo Black, who is the Supreme Court, who is I believe Black was the head of the Supreme Court at the time. He's writing for Supreme Court, rejects the argument and reaffirms the Kerr finding. This court has never departed from the rule in Ker v. Illinois that the power of a court to try a person for a crime is not impaired by the fact that he had been brought within the court's jurisdiction by reason of forcible abduction. They rest on the sound basis that due process of law is satisfied when one present in court is convicted of a crime after having been fairly apprised of the charges against him and after a fair trial in accordance with constitutional procedural safeguards. That's Frisbie v. Collins, 1952. The court went further and addressed the Federal Kidnapping Act might provide an exception, but it concluded that the severity of the sanction under the Federal Kidnapping Act made it unlikely that Congress intended them to apply to law enforcement officers. So the conviction stood. Then we get to the case of, we go to 1992, right? United States versus Alvarez-Machain. This is one of the most important tests next to the case that's coming from Maduro. And it involved DEA agents. It involved the DEA, Mexico, and allegations of the Big T and the Big Red Rum. Look on the screen and you'll see what I'm talking about, okay? Humberto Alvarez-Machain was a Mexican physician allegedly involved in one of the most brutal crimes against a U.S. law enforcement officer in history. I'm not going to get into what happened. You can see it there. Go to the website, go to justiceisaprocess.com. You can read about what happened. But it's brutal. It's terrible. And they believe that Alvarez-Machain participated in this act. When negotiations for Mexico for extradition failed, the DEA took matters into its own hands. And on April 2nd, 1990, Mexican nationals hired by DEA agents kidnapped Alvarez-Machain from his medical office in Guadalajara, flew him in private plane to Texas, and handed him over to U.S. authorities. Now, the Mexican government lodges a formal diplomatic protest. The district court dismisses the indictment, rules that the kidnapping violated the U.S.-Mexico extradition treaty because there was an extradition treaty between U.S. and Mexico. The Ninth Circuit affirms it, meaning they agree. And then the Supreme Court reverses it, with Chief Justice Rehnquist writing for the majority, acknowledging that the abduction may be in violation of general international law principles, but he noted that Mexico had protested through diplomatic channels, but he concludes that the extradition treaty did not explicitly prohibit kidnapping and therefore could not be read to prohibit it. You can't read crazier stuff, but they're saying it didn't deal with that. So Justice Stevens writes a blistering dissent, and he's joined by Justice Blackburn and Justice O'Connor, and he argues that the decision encourages governments to engage in additional acts of international lawlessness. And this is exactly the thing that we have to be concerned about in what happened here in this case. That yes, when governments engage in this type of behavior, it opens the door for future behavior. It opens the door for other nations to do the same thing. And that's what we have to protect against. That's what we should be operating under. We are the lawful. We're not the lawless. So when we do things like this, we become the lawless, and it's very dangerous because it sets the precedent. Because if we're not willing to learn about the law, who is? You've got leaders out here that don't care. We're supposed to be the shining example that we can do things lawfully and get things done correctly. And, that was what those three justices said. But here's the twist. Despite the Supreme Court ruling that the court had jurisdiction, Alvarez-Machain was actually acquitted. Not just acquitted, he wasn't even acquitted by a jury. The trial judge, and this is so rare, you don't see it at all, happen very much, that they ruled that the government didn't even make their prima facie case, meaning in the light most favorable to the government, the evidence that was presented was so weak, it didn't even meet that standard. And acquittal was granted before sending the case to the jury, which is unbelievable. And then we have the Noriega precedent. Now, this is where President Trump and his team are believing they have their authority to do what they did. They're citing this 1989 invasion of Panama. I'm sure some of you, I remember my dad telling me about this. This is something my dad was all up in arms about when it happened. And it was a prosecution of Manuel Noriega and it's very similar to how this all went down. And it is inside of this that you're going to understand the defense that Maduro will plan to put up. On February 4th, 1988, a federal grand jury indicts General Manuel Antonio Noriega, the de facto leader at the time of Panama, on drug trafficking charges. The indictment alleges that Noriega had exploited his position as commander-in-chief of the Panamanian Defense Forces to assist and protect international drug traffickers, including the Medellin cartel, in exchange for personal payoffs. For nearly 2 years, Noriega remains in power in Panama. He defies U.S. demands that he step down. He annuls national elections in 1989 when international observers said he lost. And he declares hostilities against the United States. And again, all of this, I think, is known because he's trying to avoid losing what he thinks is the only thing keeping him from being prosecuted, which is something Maduro thought he had, and you're going to learn about what that is. On December 20th, 1989, President George H.W. Bush orders the invasion of Panama. And the stated purpose was for safeguarding American lives, restoring democracy, preserving the Panama Canal treaties, and seizing Noriega to face federal drug charges. They unleashed 27,000 U.S. troops down to Panama. Noriega initially evades capture, but eventually takes refuge at the Vatican embassy. And U.S. forces surround the building, and then now, I remember my dad telling me about this, they blasted rock music to pressure him into surrendering. And on January 3rd, 1990, all right, you think it is absolutely no accident that was the date that this happened. Exactly 36 years before Maduro's capture, Noriega surrendered to U.S. authorities and is flown to Miami to face trial. Noriega raises multiple defenses. Head of state immunity. He argues that as the de facto head of state of Panama, he is entitled to immunity from prosecution. The court rejects this. And again, you're going to see this is exactly why the United States in 2024 decided at that time, after there was dispute over the election, that they were no longer recognizing Maduro as a head of state. And this is why, because they're going to make that the reason why they're going to say he should not receive head of state immunity privilege. And the court held that it can be withheld or granted, and that the U.S. had, and that one of the factors is that the U.S. had never recognized Noriega as Panama's legitimate ruler. Now, Maduro is a bit different because the world recognizes him as a legitimate leader. He was elected, even if it was disputed. And the question at hand will be, is it enough that just the United States government simply says, we're not recognizing him as a leader? Is that enough? And that's going to be up before the United States Supreme Court. That will travel through the 2nd District or to the 2nd District Appeals Court or 2nd Circuit Appeals Court. It's going to go all the way up, and that's going to be decided, and we'll see what they say. Illegal capture. Noriega argued that the manner of his capture through a military invasion was shocking to the conscience and in violation of the laws and norms of humanity. The court rejects this under Ker-Frisbie, but you're going to hear the shocking to the conscience is what the basis is going to be, and it may be viewed a tad bit different here, and we're going to go over that. And then there was an extradition treaty violation. Noriega argues that his capture violated the U.S.-Panama extradition treaty. Citing Alvarez-Machain, the court rejects this, holding that the treaty did not explicitly prohibit the method by which he was brought to the United States, which is kidnapping. So that I don't know whether or not I don't know what the treaty is, but I'm assuming that's not included in any extradition treaties. So again, a dangerous precedent that is set. If it's not included, United States courts are going to recognize it, and that means that what's good for the goose is good for the gander. It could happen to our leader if somebody decided to come in and get that stupid. But, you never know. Prisoner of war status. Noriega claimed that as a prisoner of war under the Geneva Convention that the court lacked jurisdiction. The court acknowledged his POW status, but held that the Geneva Convention permits prosecution for pre-capture crimes like drug trafficking. Noriega was eventually convicted in 1992 on 8 of 10 counts, sentenced to 40 years in federal prison. He served 20 in the United States. He was extradited to France in 2010, served a sentence for money laundering there, and then back to Panama in 2011, and he ended up passing away in 2017 at 83. Now, we break it down here for you, okay? And again, this is all on our website. Why this is a much different case. This is not Noriega 2.0. The parallels look similar, but there is a lot of differences. So let's go over them. Status. 1989. Noriega was a de facto military leader who never won an election. Maduro in 2026 is an elected president, regardless of how disputed that election was. I mean, after all, we have disputed elections here. So, this again is a very dangerous president, recognized by a majority of world nations. Declaration of war. There was no declaration of war by Maduro or Venezuela on the United States. Panama's National Assembly did declare war on the United States, making this a completely different situation. America's presence. There was 10,000 troops already stationed in Panama. There was absolutely no U.S. military presence in Venezuela prior to this invasion. Strategic assets. The United States had no comparable assets to the Panama Canal neutrality at stake. That was already something that was in effect. There's no comparable U.S. strategic asset near Venezuela or at Venezuela besides oil. Civilian casualties. Estimated hundreds of Panamanian civilians have been killed. Unknown but reported. Investigations ongoing. International response. The UN General Assembly condemned the invasion 75-20. Clearly, there's not been time for any type of UN assembly, but it's been at this point today, based on news reports, near universal condemnation, even by our closest allies like the UK, France, Germany. All of them have condemned this act. And the UN Security Council is apparently going to be convening a emergency meeting at some point in the near future. Congressional authorization, none in either case. And post-capture governance. U.S. recognized Guillermo Endara as president. Panamanian government continued. Trump announces that the U.S. will run Venezuela temporarily, which really throws a really different look on this, and not a good one for us. The critical distinction that's going to echo through the legal proceedings is that when the U.S. invades Panama, Noriega had declared war. American citizens were allegedly in danger that were in the area. Troops were already on the ground. And none of those conditions existed at all in Venezuela at the time this happened. One retired Army colonel puts it, and this is somebody who was quoted today, there were tens of thousands of Americans in Panama allegedly in danger. Noriega had declared war on the U.S., and neutrality and protection of Panama was at risk. And none of that is here. It's not even close to being the same situation. So, the questions. Let's go over the legal questions, because this is where we are concerned about right now on this channel. This is what you'll be watching. This is what you need to understand as a viewer of this channel, and someone who is concerned about due process, because it's in due process we trust. It's in due process that we believe, or I believe, my father believed, that ensures fairness, and that is what separates us from everyone else, is the belief and that due process applies to everyone, regardless of how heinous the action is, regardless of how terrible the crime is. Now, the first thing that's going to be is a battle over the U.S. non-recognition to strip head of state. The United States has not recognized Maduro as a legitimate president since the disputed election of 2024. But the question is, does that matter, right? Because again, there might be some countries out there who witnessed some of our elections that were disputed. And would it matter whether or not this other country says, well, I don't believe that was fair? What authority does a country have to simply say, we don't recognize you, especially when the rest of the world does? In the Noriega case, the court held that the head of state immunity is a privilege which the United States may withhold from any claimant. But Maduro isn't a military strongman who seized power in a coup. Some might say he's a military strongman, but he didn't seize power in a coup. He was elected in 2013 and in several disputed elections since. He's been inaugurated. He's recognized by a majority of the world's nations. He's appeared on behalf of these countries as a head of state. He controls the government, the military, and the institutions of the Venezuelan state. Does America's decision to say, hey, we don't recognize you, automatically convert that leader from head of state into private criminal defendant? And if so, what would stop any future administration from simply refusing to recognize a foreign leader and then claiming the right to invade and arrest them? So this is something that is going to give great pause to the Supreme Court and to any judge who's deciding this. This is going to be controversial, and this is going to be something to watch for. And I can't wait to see how this plays out. The next thing is, at what point is capture too bad for good detention? The Ker-Frisbie doctrine has survived, as you've seen, over the years. It survived invasion of a small Central American nation. It survived going into Mexico. But can it survive this? Because this operation involved airstrikes on a foreign capital. It destroyed military and civilian infrastructure. It killed civilians and military personnel. The exact number right now is being determined. It created a power vacuum in a country of 28 million people, and it was condemned by everybody. France, Germany, United Kingdom, these are some of our staunchest allies. The Second Circuit in the 1970s did create a narrow exception to Ker-Frisbie. And it's important because this was in the Second Circuit, the same circuit that will hear this case if it heads out, once it heads out of New York District Court or out of the federal district court in New York. And it was in a case known as United States versus Toscanino. I encourage everyone to look this case up, suggesting that if capture involves the big T, I can't say it, you can see it on the screen, or conduct, and this is the important part, that shocks the conscience. Now you can see why it's very important when you saw that picture of Maduro blindfolded, but he had a water bottle in his hand, that it's important that the big T is not something that happens, because in that case, in the Toscanino case, the court held that the actions that were taken prior to delivering to the United States were so bad that it shocked the conscience, involved the big T, and thereby he was not going to be tried. It's only been applied that I know of in the Toscanino case, but Maduro's defense is going to essentially, this is where we were just talking earlier, the shock the conscience is an invasion against all international laws, coming into a country, bombing. Now, the Trump administration is going to say, no, we were lawful. This is someone that was declared a head of the Big T organization. They're doing all these bad things, and therefore we went in as part of a lawful act. We don't recognize this individual as a leader. He came to power in a disputed election, and we were coming in to come get a criminal defendant. And regardless, again, shock the conscience? No, this doesn't shock the conscience because this is just what we had to do. But again, a judge in the Supreme Court is going to have to find out, is a military invasion of a sovereign nation without congressional approval, strikes on civilian infrastructure, and the capture of a sitting head of state recognized by the entire world as a head of state, does that shock the conscience? And if that doesn't shock the conscience, what in the world would? Okay? Now, when the other thing we're going to have to deal with, what happens when international law violations are as massive as what we have? Article 2, Section 4 of the UN Charter provides that member states shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. And the UN General Assembly's 1974 definition of aggression explicitly includes the blockade of ports or coasts by a state by the armed forces of another state as an act of aggression. That was committed in December. UN human rights experts already condemned that. That's already been condemned. So we have that. and they said there was no right to enforce unilateral sanctions through an armed blockade. I'm not here to say whether that was right or not. I'm just telling you that's what they did. A blockade is prohibited use of force by military force against another country under that article. The U.S. courts have historically held that violations of international law don't defeat jurisdiction under Ker-Frisbie. The Supreme Court in Alvarez-Machain acknowledged that the abduction may be in violation of general international law principles, but held that that was a matter for the executive branch, not the courts. In other words, that will be held, that's the responsibility to be handed out for the actions that were taken, but it doesn't affect his ability. If he's standing in the dock, if he's standing in the dock, if he's hearing the charges, if he's being given due process, that is the only thing that matters in the assessment of whether or not due process is being given here, and it doesn't affect that. Say, hey, this is so terrible, he's not going to hold trial. But can the position survive when the violation isn't a covert kidnapping by hired operatives, but a full-scale military invasion broadcast live on television? So again, this is going to be a big deal here, okay? Because this is like a step up. There's been nothing like this done, and we're going to find out, will our courts rubber stamp this for the world to see? And when they do, what will the reaction be of the rest of the world? Like I said, this has massive, massive impact all over the world about what type of nation we are and how we view ourselves. Are we the lawless or are we the lawful? And we have to show the world we're the lawful. Was this an act of war requiring congressional authorization? This will be something I'm sure there will be congressional investigations on, and there will be a bunch of things I'm sure that will investigate this in the coming years. But the U.S. Constitution grants Congress, not the president, as we all know, the power to declare war. And that the War Powers of 1973 requires the president to notify Congress within 48 hours of committing armed forces to military action and to terminate such action within 60 days without congressional authorization. The Trump administration are right now pointing towards a 1989 legal opinion authored by then U.S. Attorney General William Barr that the president has constitutional authority to deploy the FBI to investigate and arrest individuals, even if those actions contravene international law. So this is important. I mentioned this earlier. FBI agents were embedded in them with the Delta Force. And the reason why is because that's the exception they're going to point to when they go and Congress is investigating, or if a judge is reviewing this as part of the Maduro's pleadings, and they're going to say, under the 1989 legal opinion, we had right to do this. We sent the FBI with them. This was for them to go in and arrest. This was not an act of war. This was not a coup. This was not an attempt to take over a sovereign nation. Democratic lawmakers, of course, have already come out, as you would expect, they're the opposing party. Senator Andy Kim stated that Secretaries Rubio and Hegseth looked every senator in the eye a few weeks ago during the congressional hearings they had and said this wasn't about regime change. He says, I didn't trust them then, and we see now that they blatantly lied to Congress. Of course, this seems to happen all the time, but there is a crime out there called lying to Congress. So we'll see how that plays out as this progresses over the years and this is looked back upon. Representative Richie Torres stated, the U.S. Constitution vests the power to declare war in Congress. No single individual has the authority to commit the nation to a war of regime change without congressional authorization. While questions of constitutional war powers don't directly affect this court's jurisdiction, they will color the entire proceeding, and they could affect the court's views of the legitimacy of the capture. In other words, if the court may view this as rubber stamping an act that they say, hey, this should have never happened. This was an act of war, and as a result, we're not going to rubber stamp this. And any ruling in favor of it would be essentially rubber stamping it. And with this being in New York, that's not a Trump favorable state. It's not a Trump favorable circuit. He hasn't gotten very good treatment there in his own cases. This could be, we'll see how they handle it. And then, of course, this is a big one. And this is the President of the United States. It's a fair trial. Sorry, I skipped the part. It's the fair trial principle. And the question is, I seriously myself am wondering this. The President of the United States, and this is the problem with something like this, there is no greater taking away of an individual's right to due process and fairness and a right to a fair trial. And when you have the President of the United States essentially saying this guy is guilty. This guy is so guilty we sent the military in. And I watched it. And we violated international law to go after him. I don't know how you could ever get this guy a fair trial anywhere, because essentially it's created the situation where you would almost be saying, you vote with Maduro, you vote Maduro not guilty, you're voting against your country. That the only vote for your country is guilty. Now, of course, opponents of the current administration and opponents of this whole situation might see things different, and that's why we would put them towards a jury. Now, again, to a jury. That's the magic of a jury trial. And Maduro, who I believe is a pretty brutal dictator himself, and I don't think he probably appreciates due process like he's going to appreciate it in this case, he's going to find that you don't just get to say guilty. 12 jurors come together and have to hear the case, decide the case, and decide the type of country we're going to be, and decide whether or not the laws have actually been violated, and decide how this goes. I don't know the strength of the case. I haven't seen the evidence. I'm not even going to comment on it. But I guarantee you they're going to ask for a change of venue, although I don't know where you would change the venue to. Whether it's, New York is no more worse than Chicago or D.C., okay? I don't know why New York would be worse than that. I don't know that defense attorneys would want to move it out of New York, but we'll see. But it creates a very interesting problem for getting him a fair trial. Now, then there's the global president problem. What do we mean by that? That if the United States can unilaterally invade sovereign nations to capture their leaders, what principles prevents other nations from doing the same? And if we can go and invade countries based on a domestic indictment, what stops Russia from doing that? What stops China from doing that? What stops them going in and taking out a leader that we find friendly? And where is our basis to object to it going to be? Because when we disregard the legal limits, as one scholar wrote before this invasion happened, in regards to other things that were happening, but if we disregard the legal limits on the use of force, it undermines the very norms that it relies upon for us to condemn this type of aggression elsewhere. It weakens our credibility as a nation when we're calling out invasions in Ukraine, and when we're dealing with, if China were to go and invade some of the territories that we have. Again, we don't want to make this too political, but the idea here is like Taiwan or look, these are things, or let's say North Korea went into South Korea. These are things that we have had the ability to talk against, because we have said there's a way to do this humanely, and there's a way we settle these things, and it is not this way. If we are going, and again, I guess it all fits in with why you've seen when Hegseth was making the changes to the military that he is, and he's trying to strengthen the military and get people in. You can kind of understand now why all of this is going on, because they're understanding that we are going to be inviting this to happen, and we are going to have to be ready to decide what we're going to do. And it's not going to be who settles this in court. Okay, that's where we're heading. French Foreign Minister Jean-Noël Barrot states the military operation, this is the French Foreign Minister, states that the military operation that led to the capture of Nicolás Maduro violates the principle of not resorting to force that underpins international law. France reiterates that no lasting political solution can be imposed from the outside. The Brazilian president Lula da Silva called the capture an unacceptable line and a grave affront to Venezuela's sovereignty, and yet another extremely dangerous precedent for the entire international community. Even the Germany's conservative Christian Democratic Union called the operation a coup, with Trump saying, with President Trump, the U.S. is abandoning the rules based on the order that has shaped us since 1945. And it appears the international consensus right now, as it stands tonight, is that the operation has damaged the framework, the World War II's framework of international law. But the question at this point that everyone will be watching is, where were U.S. courts falling on this? Because remember, we have the courts, we have Congress, and we have the president. We have three branches of government, and there's a reason why, and they check each other. Will they check the executive branch and what they've done here? Will they put guardrails on this? Or are they going to say, no, hey, it's a free invitation to do what you want to do. Now, what comes next? Maduro currently, as I stated, he's aboard. As far as we know, we've not been informed that he's made it to New York yet. He'll be transported to federal custody. He's going to be held at MDC, I'm sure, Metropolitan Detention Center in Brooklyn. It's a horrific place to stay. One of the worst prisons or jails in the world. And here's what you're going to expect. Within 24 to 48 hours of arriving in New York, he's going to be presented to court. Charges will be read. Bail will be addressed. He'll be detained. At that point, he will have made it to court. At that point, the court will have jurisdiction. When he's going to plead not guilty. And then you're going to see the defense attorneys are going to immediately file the motions to dismiss for lack of jurisdiction, to challenge the court's authority under the Ker-Frisbie, with the exception of Ker-Frisbie, not under Ker-Frisbie. Ker-Frisbie allows to go on, but as the shocking conscious exception to Ker-Frisbie, they're going to argue state immunity, they're going to argue violation of international laws, and they're going to say that he was obtained through a military invasion, and that process is going to start. The government's going to cite Noriega, they're going to cite Alvarez-Machain, they're going to cite the entire 140-year line of Ker-Frisbie cases we just went over, and they're going to argue that Maduro, and he was brought to court, and now the court has jurisdiction over him. And a federal judge will make a decision, and if the judge dismisses it, the government's going to appeal. If the judge allows the case to proceed, Maduro is going to appeal. It's going to go to the Second Circuit Court of Appeals, the very court that gave the Tablerano, I believe I said that correctly, exception, and it's going to go before them, and they're going to see this, and then it's almost 100% going to go to the United States Supreme Court because of how unprecedented this case is. Then, it's going to take months to go through these things. It'll probably take, if not years, to go through these issues, and then a trial is going to happen, and that trial is going to be a sizable, long trial. It's not going to be a short trial. These type of conspiracy charges are going to take a lot of time to go through. And in the meantime, Maduro is going to sit in federal custody, and the nation of Venezuela, 28 million people, will watch and see what we're going to do, and see what running their country actually means. Now, this is exactly the type of situation that my father fought for. These are the people my dad fought for, okay? Someone like Maduro. Maduro is not someone who's sympathetic. He's not a good man based on what we've learned. Although I haven't seen the specific evidence, but I'm saying based on what I've seen, based on press reports, based on how he's run his country. But it's not about him being a good man. It's about whether or not we as a sovereign nation can extract the sitting head of state, try him as a civilian in a courthouse, based on a 140-year-old doctrine that says it doesn't matter how you got the defendant in the courtroom. And, is that okay? Does that sit well with the American people? The idea that we're going to say it doesn't matter where we got you from. And to me, I think that's kind of lost on some of the other principles. It does matter where evidence comes because it can be excluded. But it doesn't matter that we lawfully show the world that we're not lawless and that we got this defendant lawfully. Something just doesn't sit right with that. But that's going to be a decision for the courts. And you can bet that this doctrine, the Ker-Frisbie doctrine, sorry, lost it in my head. The Ker-Frisbie doctrine, it's going to get tested to the absolute limit. And if the answer is no, okay, that it doesn't matter how we got the defendant into the courtroom, we will have discovered that even in American law, that there, or if it matters, I guess I should say, that yes, for the first time, this will be a capture that would be too bad for detention that follows to be called good. That there are captures that are too bad for detention that follows to be called good, which is the premise that this is built on. We're going to cover this. We're going to watch. Now, we're not going to have cameras in the courtroom. We're going to have to do this through covering news, I'm sure our friends at Law and Crime will have people there outside the courthouse. We will be following it. It's going to be an unprecedented case. And we are going to be looking to say, hey, Does this matter? Does it matter how we got him? And if it doesn't matter, well, we're sit with that. How will that sit with the American people? But it's important that you understand what's going into this so that we can answer these questions, because it matters what we as jurors and potential jurors in this case look at when you're looking at this. And it matters what we're asking when we're asking judges to check the executive branch and say, is this okay? Because we are being defined. We as Americans, who we are, who America is being defined by the actions of our government and by the actions of our judges and by how we are going to handle what is absolutely and seems to be a not so good man and not a good person. But it is how we handle the not so good man, the terrible person. It is the idea that that person gets due process, that that person gets humane treatment, that that person's rights are respected, and that things are done the right way. Otherwise, we're no different than them. We're no different than what we're condemning, and that can't be the standard. That can't be where it's at. Let me know what your thoughts are. Let me know how you feel about that. Let me know what you think knowing all this. Read this article. Pull it up. Make sure you're reading it. And let me know. Let me know your thoughts. Because I want to know, do you think there is a limit? Or do you think it doesn't matter? Do you think that it matters not how someone comes to court? Do you think that should be something that should be taken into account? If the government commits just as heinous of a crime to get the person there, if they break the very laws that they would send someone to prison for life for, kidnapping is a capital crime in almost all states. Is that okay? Are we going to make that carve out? Because if we do, what does that make us? How are we different than them? Consider that, guys. And remember, in due process we trust, and until we talk again, let justice prevail.
System's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people